I will say that how I see this on the show cause docket right now is the commissioners are asking the property managers, have you seen a kid? Have you seen a child in the unit? Do you have any knowledge that there's a child? Uh, I don't think they're going so far necessarily as to say, is anyone working for a school? But that question I have heard asked many times on the show cause docket. And so at the very least, it should scoop up families with children. The rest of it though, in my view, that's going to be up to the tenant to bring to the court's attention because I don't think the courts landlords and property managers aren't keeping track necessarily of people's changes in employment or so on and so forth. So that will be one that the tenant will have to really plead
Yeah,
and have some support for.
yeah, absolutely. I think as a practical matter, that would be an affirmative defense because, as Beverly stated, the court's inquiry is only going as far as are there any children of school age in the household, and that's as far as they're going, as far as their inquiry on the record.
Yeah. Next slide. Okay. So we are almost at the end of the winter eviction moratorium. This is a fairly long period, November 1st through April 1st. So what we are seeing as far as writs that are being issued now is they're being stayed until April 2nd. June 22nd, I want to say, is what they're being stayed for when there's a school year or student or educator components to that eviction. Uh, the and then the well, I'll get to the second part as well, which is that if there are health or safety code violations present, the landlord or the owner can also not proceed with an eviction. And so, as far as the first, that's having some implications. Like I said, they're being stayed. The sheriff's department is who actually carries out the physical evictions, and so they've got quite a backlog, as I understand it. Adam, I don't know if there's anything you want to add to the winter eviction piece.
Let's see, yeah, with regard to that, and just in application, I can tell you right now what the courts are doing is they're allowing the eviction actions to proceed, and how they are enforcing this particular prohibition is they're just stating that that the writs cannot issue until after April 1.
Mhm.
And so what's been happening essentially since December 8th until now, all these writs have been ordered by the court, but they haven't been issued by the clerk yet. So when April 2nd comes, there's going to be a huge dump of writs on the civil unit at sheriff's office, and it's going to be problematic as far as how they're going to manage serving all of those writs, right? Because you're going to have a several month stockpile that hits all at once. So at that point in time, you can expect that there will be a pretty serious backlog as far as getting the physical eviction component of an eviction completed by the sheriff's office. Because not only are they going to have this backlog of writs, but they're still going to have their concurrent writs, right, from cases that are continuing to go forward. So it'll be interesting to see how all of that works out.
I'd like to, I'm sorry. I'd like to know the standard of proof of code violations. Is that
Oh,
the existence of one or an allegation of one?
So that's an interesting question. The show cause docket, there's summary proceedings. So
Yeah.
yeah, so the standard is the normal civil standard, right? Preponderance of the evidence. So whether or not that's good enough for the particular commissioner is going to be up to that commissioner. So if there are contested issues of fact, that really should be certified for trial, and that, as I understand it, are fairly fast tracked.
yeah.
We're looking
So
at a couple months.
yeah, under statute, they're supposed to. So just to repeat the question is regarding the second portion of the slide, the standard proven code violations at the show cause hearing. Um, if there's a question of fact, so typically if the tenant can provide any type of evidence that would call into question whether or not there's been a code violation, that would have to be determined at trial. As far as setting the matters for trial, the departments are statutorily obligated to get them done in 30 days, but that has not been the case. So it's been closer to 60 from what I've seen. But they do try to get you in there as soon as possible. But if the tenant can provide evidence that raises a question of fact for the commissioner who's presiding over that hearing. They're probably going to get bumped to trial. So I would say that would probably go beyond just a declaration, but if it has to do with condition of premises, if they have a sworn declaration that shows photographs of a potential code violation, I think that is going to get the tenant to trial.
Or public records establishing that, yeah.
Have there been any rulings on the failure of the county, the Superior Court, to schedule hearings? This would be, is it jurisdictional? Would it be subject to some form of remedy to whomever is not getting a hearing in a right time?
Well,
it's statutory.
Right.
You should. or
yes.
shall.
So I'll be honest with you. Since COVID, the eviction proceedings just have not been able to keep up with their summary statutory deadlines, right? Evictions by statute are supposed to be a summary proceeding, and they're supposed to be an expedited proceeding. And practically speaking, the system just hasn't been able to keep up with those requirements. So I haven't seen that challenged yet. I've heard landlord attorneys argue it quite a bit when things first started to get backlogged. But as far as actually taking action, I haven't seen any successful attempts, at any rate, to get some type of judicial relief to force the courts to keep current with whatever the statutory requirements are.
Obviously, damages would be mounting, though, for the delay. Yeah.
Yes.
We have a couple questions in the chat.
Okay.
The first one is, if you name authorized occupants in the lease, does that limit the applicable pool? AKA, does the eviction prohibition extend if the tenant has a guest? AKA not a named occupant?
That's an interesting question. I would say probably no, that just mere guess would not trigger the school year moratorium.
Yeah, so here's the way I would kind of dissect that a little bit. So as a matter of course, a landlord is typically going to name all other occupants as the caption. And the reason for that is if you get to the show cause hearing and the tenant is there and he says, oh, by the way, my friend who's been living with me for the last 6 months is also residing there. If the writ just names the tenant without anything else, the sheriff is going to show up and there's going to be this extra body there that they're not going to be able to evict, right? So you need to name all other occupants as a catch-all. If there's a tenant, if the unauthorized occupant is truly an unauthorized occupant, I don't think that they're going to be entitled to these prohibitions. And I think we'll get to this a little bit later. With regard to the city of Tacoma, you need to be careful because one of the prohibitions is that you cannot evict an immediate family member. And so that person may not be on the lease. So if you have a tenant and brother Bob has decided to move in under the Tacoma, under the Fairness Code, that immediate family member is allowed to be there as long as they're not violating any occupancy codes. So you have to be careful of that if you're going after unauthorized occupants as a basis for eviction. Sorry, it's a little bit off topic, but
One
yes.
more follow-up question. What if it's a utility shut off and they just turn the utilities back on just before the hearing, and the rent arrears would be that any daily damages as a code violation?
As a
Could you repeat that?
Yeah.
What if it's a utility shut off and they just turn the utilities back on just before the hearing? And in parentheses, and the rent arrears would eat up any daily damages from the shut off.
You mean are you talking about a failure to pay a utility bill by the tenant?
I believe that is a question. Question in the chat.
Well, so utilities are kind of a tricky business, right? Because if the tenant is obligated through the lease to be responsible for the bill and the bill's put in their name, if they fail to pay, then for the most part, the landlord is not under an obligation to cover that rent, or I'm sorry, to cover that utility bill. If the utilities get turned off, then that is the tenant's issue for the most part. And it can be a basis for an eviction. Now, if it's a landlord's responsibility, a landlord cannot turn off utilities under any circumstances. And so I'd say if the landlord turned off the utilities and then right before their own eviction hearing, based upon other matters, they turn them back on, I think the commissioner may have a little issue with that as far as them proceeding on with whatever the basis of their eviction, because they were technically in violation up to the show cause hearing. So I would not tempt fate with that.
In the past, and I haven't done a Pierce County Superior Court eviction in quite a while, but in the past, the writs and the lawsuit said all persons present. Are you saying the Pierce County Sheriff wouldn't honor that if there are persons present?
I think it's important for you to name any persons that you haven't identified by name that are occupying the property in the caption and when you get your writ. Because if you don't do that, then you may have a problem. Then you're putting the sheriff in the position of ejecting people that are not on their writ, and they may not be willing to follow through with that.
I guess it's a practical matter. Do the sheriff's civil deputies ask for people's names? I mean, unless they come up and say, I'm not named, practically, I mean, it's a problem for the sheriff and for the landlord.
Yeah, it's not a problem if you have all other occupants in your caption, though. If you name all other occupants in your caption, then there's not a problem. They're going to clean house.
Okay, next slide.
Next slide.
Then we kind of go back to the other question. So my sister lives somewhere and she has a daughter come stay with me, or a friend or anybody just brings a child in school over to my home. They don't have to be in the lease or anywhere at all. That home is protected once that child is got a pillow and a blanket in my home.
Well, potentially, because it's,
Any resident is the definition.
well, occupant who uses it as a dwelling place. So I think you would have a problem there during the school year.
Which says, yeah, under the
Yeah.
school year, I mean, it seems super clear.
Right, and so the question is essentially if a minor comes into a household that makes it their primary residence, is that household now eligible for for these prohibitions, right, regarding
The school year.
the school year? And
Right,
so,
because it says any resident, it's defined not as a tenant, an occupant, it's any resident. So if the child is there for a week or 2 weeks or 3 weeks, or maybe I just wanted to bring in a child so I don't get evicted. So I bring in a child and give them a bed in the bedroom. This law applies.
yeah, it's potential.
And
No, it's by definition, it's not, I mean,
So,
eviction qualifies for dwelling unit if the tenant, which is defined, or any resident is a child.
and we're not wearing black robes today, unfortunately. But I would, when it comes to those types of questions, okay.
Right,
So,
that's, you know, 500 bucks.
and so the Residential Landlord Tenant Act provides that any act by either the landlord or the tenant has to be done in good faith. And so I think if you can show that the tenant is acting not in good faith and bringing this minor to come strictly for the purpose of being able to take advantage of the Fairness Code, you may have an argument against a strict interpretation of that.
But risking litigation costs $500 and
Sure,
potentially $10,000 for a home.
potentially, sure.
Okay, that's good, thanks.